Ich sehe, wir sind doch jetzt vernommen mit Abzeichen und Aussagen unser Dank zum Ebersten von der Geule. Sind wir sehr zufrieden, wir haben mit uns Aid, was hat sicher gewonnen, auf zu sein Heilig und sein Keli, durch Zinner, durch welche der Indien ist durchgegangen bei der Teves, gewisse zu dem gern zugezogene Wort verheben, aber sie so auskommen, bei ihm kommt es, es ist im Ganzen, es ist ein bisschen wieder so ein Sein, wie es arbeitet. Aber wir haben da mit uns Aid, was hat ja dem Schuss zu sein dort, und das ist Rebnossen Lewin. Mehr Leben wir jetzt haben die Gelegenheit zu hören von ihm allein, sicher wird ihm geben die volle Aufmerksamkeit, so Teves zu helfen, geschemische Zachissa, als sie wird sicher gewinnen, auf zu sein, dort in jenem Mann, in jenem Minute, zu sicher sein, mancher sein, in jenem, was sie darf helfen, und in jenem, was sie tut, zu gedenken. Ihr tut, es kommt uns bei euch. Aber beschaß, ihr geht zu mit dem Zugang, hat mit sich bei Seid, a größten Siyum und Meile. Rebbe Nossen Lewin wird uns jetzt teilen sich mit seinen Überlebnissen von Jemut und zusammen feiern den wichtigen Moment. Rebbe Nossen.
Wenn Rav Shem Tov hat mir eingeladen, dass ich soll reden, heute bei Nacht, habe ich nicht gewusst, dass ich darf reden in Jiddisch. Sein Jiddisch ist sehr klar und sehr gut, aber ein Wort hat er nicht übergesetzt. Und das ist das Wort Lawyers. Ich habe gehört, etliche Mal, wie er sagt, Lawyers. Lawyers ist nicht ein jiddisches Wort. Ein Advokat, aber ein Lawyer, das ist nicht das. I am going to speak in English. With the permission of the Balabas. And again, our tradition is posken b'aksanya. You have to start by thanking the host. And Rav Shem Tov, who's a friend. Oh, the whole Olam, okay. But Rav Shem Tov is the one who came up with the idea that I should come up now, this year particularly, to come up to New York and join in the simcha that's going on today on Hey Teves. And so he gets at least the credit from me for my being here and being able to see all of you and join in this simcha. He reminded me, which maybe I'm a good lawyer, and I used to be very good at math, but he reminded me that this is the 30th year since the case began. The case began in August, the secular date, in August of 1985. The decision, Hey Teves, didn't come till 2 years later, but nonetheless, the case began in 1985. So that's 30 years. And when I think of 30 years, what is 30 years in Hebrew? It's shloshim shana, 30 years. You take the shin and the second shin, shin, with the dot on the right-hand side. But 30 years ago, the country was much more right-wing than it is today. So today, you move the dot to the left side. And if you move the dot to the left side, what do you end up with? Sus. Sus anochi alim rasecha. We're all happy 30 years later when we move from the right side to the left side. There's, sometimes the most interesting things come out even in gematrias. In gematrias. What is the gematria of Didan Notzach? Didan, 68. Notzach, 148. Believe it or not, if you take the gematria of Rebbe, you end up with 217. And we know that in gematria, 1 doesn't make any difference. Im hakoilo, you count the word together. So Didan Notzach is the day of the Rebbe, the day that we can all attribute to the Rebbe. It's not just the Dun Notzach. It's not just the Dun Notzach. Why? Because if what you also do is you take the gematria of Sfarim. What is the gematria of Sfarim? The gematria of Sfarim, Samach for 60, Pei for 80, Reish for 200, Yud for 10, Mem for 40. You come up with 390. 390. What happens with Sfarim if you have Siyata Deshmaya, if you have the help of the Rabbanu Shalom, if you have Yud K, Vav K added to 390, it comes out to be 416. And those of you who want to be interested in Gematria would figure out that 416 is the Gematria of Hey Teves. Hey Teves equals 416. Sfarim with Yud K Vav K equals 416. But that's just to start off with what speakers consider kind of a joke at the outset. The real lesson, it seems to me, in terms of the Dun Notzach and Hey Teves, is that we managed to persuade a non-Jewish judge of the rightness and the correctness of Chabad's view and the Rebbe's view. Where is there a similarity that's currently appropriate? Just look at this week's Sedra. Yehuda stands up before what he thinks is a Goyish judge. He thinks Yosef is a Mitzri, right? And he makes this incredible speech, this incredible lawyer's argument on behalf of Binyamin, and succeeds. Not because he manages to persuade this Mitzri that Binyamin is innocent, but because his words are authentic and heartfelt. My own yichus is that my grandfather, the Reisha Rav, Rabbi Aaron Levin, who was the Rav in Reisha in Poland, in pre-war Poland, in Galicia, was elected to the Polish Sejm, was a magnificent Talmud Chacham, wrote Tshuvas and Sfarim, Sefer on Torah, Hadrash v'Ho'iyun. He talks about the pasuk in this week's Sedra, where Yehuda says to Yosef, Yedaber no avdecha davar be'oznei Adoni. I want to speak in your ear. And he says, what is the meaning of that? And he explains, the Reisha Rav explains in this marvelous sefer that he wrote, according to the introduction, on the train rides that he took from Reisha to Warsaw to be in the Polish Sejm. And the Polish government paid first-class carriage for him to travel every week. He would go on Monday or Tuesday to Warsaw, and come back on Thursday from the Sejm. And in this sefer he says, Dvarim hayotzim min halev nichnasim el halev. V'gam ish kosher kabarzel baal lev abir yispoel v'yisragesh l'mashma dvarim hanemorim mitok regesh pnimi adir v'chazak. That what Yehuda was saying to Yosef came Dvarim hayotzim min halev. And he knew that even if this was an Egyptian ruler, Dvarim hayotzim min halev nichnasim el halev. The story and the account of this amazing victory of the Dun Notzach has so many facets to it, so many interesting sidelights, so many interesting details. Not all of them are known, even though recently a very fine book was put out about the Rebbe by Joseph Telushkin, which discussed in detail some parts regarding the trial after we had spoken with him. There were some things, with this audience, I can share one amazing episode, really, which I think this audience particularly would appreciate. If you followed the account of the case, the issue was, of course, whether this marvelous library of Sfarim belonged to the family, to Gurari family in part, or to Agudas Hasidei Chabad. That was the issue in the case. We were litigating. We were in the middle of the court trial when my opposing counsel one day stood up and said to the court, "Your Honor, we'd like to put on a witness out of order. Flying here today in the air, because he only has a few days available, is the leading professor of Jewish law at Hebrew University, a man by the name of Shmuel Shiloh. And he has to testify. The only time he can testify is tomorrow. We're sorry we couldn't advise the lawyer, Mr. Lewin, about him testifying, but he's here to testify tomorrow on a point of Jewish law." What's the point of Jewish law? So Mr. Hellerstein says, I will give Mr. Lewin a summary of Professor Shiloh's testimony. What is his testimony? His testimony is that the Farbrengen Rebbe could not have transferred ownership of this library of books to Agudas Hasidei Chabad because there was no kinyan. There was not a kinyan chlipin. There was no kinyan under Jewish law. And therefore, says Mr. Hellerstein, under Jewish law, there was no transfer of ownership of this library. Professor Shiloh will show up tomorrow. The judge says, well, we don't have a choice. All right, Professor Shiloh will testify tomorrow. So I go home. What am I going to do in terms of cross-examining this great expert on Jewish law about the fact that there was no kinyan? It turns out, by the way, and I knew it when it was announced, that Shmuel Shiloh was a nice American yeshiva boy. He had gone to high school and was in my high school class. Before his name was Shmuel Shiloh, it was Stanley Schimmel. But he went on Aliyah, one of the first members of our class, to his credit, a very fine man, one of the first members of our class to go on Aliyah, and he changed his name to Shmuel Shiloh, and he learned Jewish Mishpat Ivri at Hebrew University under Menachem Elon, who was a Talmud Chacham, a marvelous man, professor at Hebrew University and ultimately on the Supreme Court of Israel. Shmuel Shiloh was his Talmud Muvak, and he became the leading expert on Mishpat Ivri at Hebrew University. And he was going to show up the next day to testify, according to this summary, that there was no kinyan. But what maybe Shmuel Shiloh had forgotten was that we learned in the yeshiva together. And I maybe was even in a higher shiur than he was. So I knew a little bit. Not so much, but a little bit. Enough that the next day when Shmuel Shiloh got on the witness stand and testified that there was no kinyan, therefore the Rebbe could not have transferred the ownership of these Sfarim under Jewish law to Agudas Hasidei Chabad, I said to him, isn't it true, Professor Shiloh, this was part of the cross-examination, isn't it true that Amira legavoa kimsira lehedyotami? And he said, oh, that's right. I said, and isn't a community like Chabad considered for purposes of halacha like a hektish, like a Amira legavoa? And this was a marvelous occasion, which I seldom get on cross-examination, where a witness says, you know, I didn't think of that. Remember that? I wish I could tell you that Judge Sifton ruled as a matter of halacha that you didn't need a kinyan because Amira legavoa kamsira lehedyotami. But Judge Sifton did not pay much attention to the Jewish law questions. he decided this case as a matter of American law, New York law, and ignored really the Jewish law parts of it. But to me, personally, I have to tell you this was a high point of the trial because it enabled me to use some abilities that most lawyers in America don't have, including even speaking Yiddish and understanding Yiddish. A good number of the witnesses who testified in this case claimed that they only knew Yiddish, particularly Chaim Lieberman, who was a chief opponent of ours and testified on behalf of Gurari that it belonged to the Gurari family. So he said he understood no English, and we had to have an interpreter at the trial who stood there, and as Lieberman gave his testimony, he would be interpreted. My questions would go from English into Yiddish. His answers would go from Yiddish into English. And I can only tell you that was very difficult for a trial lawyer. My experience as a trial lawyer is question, answer, next question. Immediately after the witness gives his answer, you want to ask the next question. And there were many times during the trial, since I understood what Lieberman was saying, that I would say, he would answer in Yiddish, and I would immediately ask the next question in English, and Judge Sifton would say, Mr. Lewin, slow down, I don't know what the witness said. You have to wait for the interpreter. That was one of the difficulties in this trial, was the translations from Yiddish into English. And yet, Judge Sifton accepted the testimony and was impressed, of course, as everybody knows in these accounts, by the deposition testimony of the Rebbitzin, who I have to tell you, we told the Rebbitzin, Allahu Shalom, that what she should do is, during this deposition, wait. She say that she does not understand English so well. We'll have an interpreter there. And every time the question is asked, it'll have to be interpreted into Yiddish. She can give her answer in Yiddish. It'll be translated into English. That's going to slow everything down. She can think about the answers. There's no problem. But the Rebbitzin, amazingly, although we had told her that, after 3 or 4 questions, forget about the interpreter. The questions were asked in English, and she answered them in English. Just like that. Not trying to slow down the process. And of course, the famous answer that she gave at the very end of her deposition testimony, my father and the Sfarim belong to the Hasidim. That was an amazing answer, and I have to tell you, truthfully, I wish I could take credit for it. I didn't prepare her to say that, but she sat there, and in answer to the question of what did your father have, she said, Talis and Tefillin, nothing else? And she said, no, my father and the Sfarim belong to the Hasidim. That was very moving testimony. And of course, we had phenomenal witnesses who agreed to testify for us. Nobel Prize winner Elie Wiesel, great scholars in Halacha, in Jewish thought, who testified that Chabad, Lubavitch Rebbes do not gather wealth like other Rebbes do and try to own things personally. The case provided an opportunity for me to meet twice with the Rebbe. And I have to tell you that very foolishly, I did not, when I walked out of those 2 meetings, immediately get a tape recorder and repeat the whole conversation. Because a major subject that I am questioned about all over the world, is you had meetings with the Rebbe? Tell me exactly what the Rebbe said to you and what you said to the Rebbe. And my memory is not good enough to tell everything. It was amazing. The very first meeting we had, the Rebbe said, what language should we speak? And I said, Ich verstehe Yiddish. Yiddish. But Mr. Shestak, who was my co-counsel, said, no, I don't speak Yiddish. So the Rebbe spoke in English for the rest of that meeting and the following meeting. And the English was crystal clear and beautiful. The meetings were such that it indicated to me clearly that he knew every detail of the proceeding. He had read the transcripts and knew them and was able to point to different things in hearings that we had had before the court. It's important to emphasize, and I do it here again, although I've said it in various other forums which are not as friendly as this forum is, because I'm frequently asked, oh, Chabad won this case about the Sfarim in a secular court. Why didn't Lubavitch bring this case to a Bezdin? After all, if the books were taken, and the other person is Jewish, you should go to a Bezdin. And the answer is, we did. We wanted to go to a Bezdin. But what happened was that Barry Garari had taken out, surreptitiously, in the middle of the night, 400 valuable books, had made a list of them, manuscripts, was selling them in Europe and in Israel. And many of them were sold. Chabad ultimately had to buy many of them back from the people who purchased them, and was in the process of selling them. So the first thing that had to be done was to stop him from selling and force him to put the books into what the lawyers call escrow, into a safe place where they would be kept. The first meeting I had with Rabbi Krinsky, Rabbi Krinsky called me, believe it or not, at 2 in the morning. I and my wife still remember that phone call at 2 in the morning. And he has said since then that he did it without the Rebbe's authorization. He saw how upset the Rebbe was over the taking of these Sfarim and how he had talked at Farbrengen's about it, and he felt he had to do what he could to cure that situation. So he called me at 2 in the morning, and we arranged a meeting, and he brought to the meeting a page from the Choshen Mishpat, which talks about the fact that you can go to Arkos, you can go to a secular court, if you can't get the relief that you need from a Bezdin, either because the other party won't listen to a Bezdin, or for some other reason the Bezdin can't give you that relief. So what we wanted is we wanted the books taken and put into a safe place and an order under which Barry could not sell them. We agreed that I would draft up the papers to get that relief, to get what the lawyers call a temporary restraining order and a preliminary injunction to get that. And I went down to the courthouse and we filed the papers. And when you file a complaint in federal court, the clerk puts his hand on the wheel, pulls out a name, and he pulled out the name Charles Sifton to be the judge. It was August. Judge Charles Sifton was away on vacation, but we needed an immediate order. Mr. Barry Garari was there. His lawyer was there. We were ready to go to a judge. So there's another judge who takes the place of a judge who happens to be away on vacation. The judge who we were told to go see was a judge by the name of Leo Glasser, Glasser, obviously Jewish. And he would rule on this question of the temporary restraining order or the preliminary injunction. So we all marched over to Judge Glasser's chambers. We walked in the door, and I was delighted to see as we walked in the door, in the hall, as one walked in to his chambers, was a first page of a Rambam printed in the 1600s in a frame. So obviously he had some Jewish feeling. We sat down with Judge Glasser. He looked at the papers, and one of his first questions was, why isn't this case in a rabbinic court? And I replied and said, we want to go to a rabbinic court after we get an order that says that he can't sell the books and put the books into escrow. Then, if we get that order, we're ready to try to find a Besdin to resolve who owns the library. And his lawyer, Mr. Hellerstein, said in his presence, "Oh no, Your Honor, we don't agree. We think that once the case is brought, the court should decide who owns the library." And he said, his mother is going to come into the case on his side because she also thinks that the family owns the library. Well, under those circumstances, there was nothing we could do. The judge said, "All right, I'll hear or Judge Sifton will hear the whole case." And he gave us an order that put the books into escrow and that directed Barry that he could not sell any of those that he had, but would have to turn them over. So in fact, if anybody says to you, as many people have said to me, this case should have gone to a Besdin, the answer is we told that to the judge at the very first appearance in court, that we are going to a Besdin if the order is given that he may not sell the books. So many things about the case were really quite amazing. So much of it shows siyata d'shmaya, not only the question of Professor Shiloh and the question of the Kinyan, but for example, Chaim Lieberman testifies. Chaim Lieberman said that the books belonged to Gurari. He said that the library was a private library. Well, we discovered that after the Friedricher Rebbe was nifter, after he passed away, Chaim Lieberman continued to buy books for the library from organizations like the Jewish Restitution Successor Organization, which had gotten books from the Shoah that were brought over to America and were being sold at 5 cents a sefer or a volume. And Lieberman had ordered books for this library after the Rebbe had passed away at 5 cents a book, saying that they were being bought for the Lubavitch Library. And there were copies of his letters that he had in his apartment. In those days, they were carbon copies. Many of you here probably remember carbon copies with carbon paper, not like today when that doesn't exist anymore. Everything can be done with a copying machine. But in those days, they were thin carbon copies. And we served a subpoena on Chaim Lieberman to produce all the documents he had that related to the library. When it turned out that Chaim Lieberman, in his apartment, he was a bacher, he never got married, he lived in an apartment. Lubavitch had given him a couple of bacherim who were going to help him take care of his daily needs, because he was over 90 years old already at the time. And he lived in this apartment, and he had papers, he had documents there. And it turned out that the bacherim found and sent to me torn up carbon copy of a letter that was sent to the Jewish Restitution Successor Organization 2 years after the previous Rebbe had passed away, asking for books at 5 cents for the Lubavitch Library. Now that was good evidence that Lieberman at that time thought this was a community library. But they had been torn up and thrown into the toilet. And the bacherim fished it out of the toilet and sent it to me. And I pasted them together with Scotch tape and saw what the letter contained. It was an order for books. A few days later, they call me, they send me another letter, this one from the ashtray in his apartment. Burned, partly burned in the ashtray. Similar letter, carbon copy of another order that he made. So, Chaim Lieberman testifies at the trial. He says, no, it's a family-owned library. I say, didn't you order books for this library as if it was a community library years after the previous Rebbe passed away? He says, I don't remember that. I said, didn't you have copies of orders that you put in for that? I don't know. I don't think so. In Yiddish, of course, translated. Then I say, well, let me show you what I've pasted together here of a copy of a letter that you sent, the date being a couple of years after the Rebbe died. You sent this letter, didn't you? Oh, I don't remember whether I sent it. Well, didn't you tear up the letter and throw it down the toilet because you wanted to destroy evidence? Oh, no. If that letter was thrown down the toilet, it was because I was cleaning up my apartment and throwing up papers that I didn't need. I didn't do that to destroy evidence. Oh, Mr. Lieberman, I have another letter here. This was a letter that was burned and was found in your ashtray. Didn't you burn this letter in order to destroy evidence? And here he gives the answer, which appeared in the New York Times, because the New York Times reporter happened to be there that day, but it was a dream for a cross-examining lawyer. I said, didn't you burn this letter to destroy the evidence? And Chaim Lieberman says, no. If I wanted to destroy evidence, I would have thrown it down the toilet. It was those kinds of things that I say teach you that this trial was not just an ordinary trial. It was a trial which had siyata d'shmaya. It had the help of the Almighty. The Rebbe, I've seen from some Sfarim, himself talked about this week's Sedra by Yigash in ways that affected, that when I read it, affected what I thought happened at the trial. When Yehuda says to Yosef, Avdecha Oreves Hanar, so the Rebbe said, Avdecha Oreves Hanar, because Kol Yisrael Arevim Zelozeh. That's the message that Yehuda was giving to Yosef on behalf of Binyamin. Kol Yisrael Arevim. And the Rebbe said, Arevim is a word that not only means guarantee, but it's also from Lashon Mesikus. That Ayin Reish Beis also means sweet. Yisrael Misukim Zelozeh. He said, Jews are sweet to each other. And that's really the lesson also in terms of this case. The Jews who are sweet, the Jews who are Arevim Zelozeh, recognized the justice of our position in this litigation. Again, I could go on for a long time talking about the different things that happened in this trial. I can tell you that now, since in these last 30 years or 28 years since the decision, my wife and I have had the good fortune to travel all over the world, different places, China, India, Hong Kong, locations in Europe. Every place we go, of course, we look up the Chabad Shliach. We're hosted by him. We go to the Chabad house. Everybody loves us because I helped the Rebbe. When the case began, one of the men who was close to the Rebbe and was involved in the Rebbe's decision that I should handle this case said to me very wisely, he said, Lewin, he says, you better win this case. Because if you don't win this case, there's no place in the world that you can go. I can only tell you again that this was a case, a litigation, unlike any other. People have sometimes asked me, how does this compare with other cases? It was a litigation which, in its importance to Chabad, in its personal appeal to me as a right, correct ruling, trying to get justice, was one of the times where justice was achieved. I've seen too many cases, and many of you know that I was involved with a Rebbe appeal, which is a great injustice, one of the greatest injustices that I have seen in all my years of practicing law. But this case was one in which the system, the American legal system, worked, and it worked correctly and properly, and it resulted in this yontif, in Teves, for which we are all thankful and for which we can all be mesameach. Thank you.